your seat, please. This time I'd like to call this meeting to order. Ask the clerk to call the roll, please.
Senator Chambers Armstrong, Senator Carpenter, Senator Mills, Senator Schickel, Senator Southworth,
Here.
Senator Turner, Senator Webb, Senator Westerfield, Senator Wheeler, Senator Williams, Representative Bauman,
Present.
Representative Blanton,
Here.
Representative Bowling, Representative Bridges, Representative Burke,
Here.
Representative Chester Burton, Representative Dossett,
Present.
Representative Dotson, Representative Flannery, Representative Fugate, Representative Gentry, Representative Grossberg, Representative Johnson, Representative McCool,
Here.
Representative Miles, Representative Smith, Representative Wesley, Representative White, Representative Williams, Co-Chair Smith,
Present.
and Co-Chair Gooch.
Here. Okay, we do have a quorum, and ask the members to stay close. This is a meeting that does require us to have a quorum because of some of the business that we have here in just a little bit. I think a couple of people may have some introductions. Senator Schickel.
Thank you, Mr. Chairman. So often we have folks in the audience who are from natural resources in one line or another who are at the executive level. But today, I'm really proud to introduce Ryan Lewis to the committee. Ryan is a lineman for Duke, and he's been a lineman for many, many years. One of the guys that goes out and climbs the poles and does all the dangerous work that has to be done to literally keep the lights on and the power going. He's a supervisor of 18 other linemen, and he's here today shadowing, and I just wanted to introduce him to the committee. Ryan Lewis, if he'd stand up and be recognized.
Thank you. Glad to have you today. Is there anyone else? Senator Smith.
Yes, I have a special guest with me. Rick Baker's here. Rick had headed up LKLP, and he's one of my neighbors. But his son Noah was my first mate for many years at our sailing school, which we focused on children with autism. And the kid literally I could not have gotten through it without him. Of course, he's a grown man now, teaches. But it's good to have his father here, Rick, and a good friend of mine, and I'd like to have him stand up.
Okay, thank you. Okay, glad to have every member present. I know there are a lot of things going on out there, and we appreciate you all being here. Senator Smith, do you have anything else?
Yeah, I do. I'd asked earlier that I'd like just for us to take a moment of thought. We just experienced a period where we almost had a former president of the United States assassinated in front of us. I can't imagine what that video would have looked like and don't want to. I believe personally it was tremendous failure of what happened here. I hope there's a full investigation. I'd heard earlier today, much to just my surprise, that instead of willingly to come forward, that the Secret Service had to be subpoenaed to come before Congress. I just think that it doesn't matter who it is or what party they are. There's a great sadness in this country. I mean, I still was not alive when John F. Kennedy got shot, but I will tell you that left a mark on a lot of generations, and it's sad that something like that would happen. And here we are again, but I hope there's a thorough investigation. What I saw on there, somebody's an avid shooter, and there should have never happened. And the nonsense about that roof was too sloped, I mean, please. I mean, we're educated adults in the room. That does not fly with me. But my heart is heavy with what I'm seeing in this country. I mean, just like to ask just for a moment of silence, if we could, and reflection of how grave the situation is, and that our country comes together and much stronger after this, Mr. Chairman.
Thank you. Let's take a moment of silence for our country and for to be thankful for everything that has happened since then. Thank you. And certainly, I think many of us do have share your sentiments, Senator Smith. But we do have business to conduct, and we're going to do that. And first, we also have to approve the minutes. So we have a motion to approve. Motion, second?
Second.
Okay, motion is second. All in favor say aye. Okay. All opposed, like sign. The minutes stand approved as read. So we're going to have a presentation to, as you know, is it every other year or every year? Every year we have to, have a public hearing and a presentation on the Low-Income Home Energy Assistance Program. It's a program that so many people out there desperately have to have and need, and they do a lot of great work, and we are so thankful that that program is there for our constituents and for much needed Kentuckians. And so at this time, we would like to start by asking some people to come forward. I think we have Todd Trapp. He is the Director of the Division of Family Support for Department of Community-Based Services for the Cabinet and the Health and Family Services, and Rick Baker, Executive Director of Community Action Kentucky. Gentlemen, welcome, and introduce yourself, please. I have introduced you, but for the record, please introduce yourself, and the floor is yours.
Yes, thank you, Representative. My name's Todd Trapp, Director of the Division of Family Support.
Yes, and I'm Rick Baker, Executive Director of Community Action Kentucky. And before coming to Community Action Kentucky, I spent 34 years with the local community action agency.
Make sure your mic is on.
Yeah, it was on.
Yeah, I just pull it up.
Okay.
All right. Well, thank you all for having us today. Appreciate this opportunity to present on LIHEAP, if you would. So we'll start with a little history. LIHEAP was established in 1982. It's essentially a safety net program focused on heating and cooling assistance and also energy conservation through the weatherization program. So it can help low-income households meet immediate home energy needs, and it's designed to do that to focus on those with the lowest incomes and the highest energy cost based on their income and their fuel source. And so we have a benefit matrix that we use to issue benefits. In state fiscal year 24, $47 million was spent on LIHEAP. So you can imagine that helps a lot of utility companies out there and all the families. We'll get to some numbers of families that have been impacted a little later in our presentation. We estimate about $58 million for FFY 2025, and it's 100% federally funded.
Can I ask, how much of an increase is that over previous year?
I don't have that number specifically. I think it was in the 40s, but we can get that back to you.
Okay, thank you.
Yep. So about $400,000 is retained by DCBS for use in preventative assistance. That's for child protective services, so for families that may need help with an energy bill to prevent child from being removed or to assist that family in bringing that child back into the household. 15% can be and is here in Kentucky allocated for weatherization. We do that through, in contract, through Kentucky Housing Corporation and then through the 23 local community action agencies. And then 10% can be used for administrative costs, up to 10%. Usually it's a little less than that. At least 90% has to go out for benefits.
Senator Smith, do you have a comment or question?
Yeah, I just, when LIHEAP first had started out years ago, people would take the vouchers and go and get kerosene, say it's in the winter. They could even get stoker coal, house coal, as we call it at home. And so I knew about the winter stuff, that you could go purchase this stuff. I was going to ask you, I think you answered it. So in the summer, where I need to cool my home, and I have a bill that I can't afford or whatever, I can go apply and get the voucher, and then I take that to when I pay my utility is how it is, or do you all take my information and then you apply it toward the utility?
If it's a metered fuel, I think generally we apply it to the utility. It's only those bulk fuel where they can pick it up, some of those bulk fuels where it's a voucher type system.
And correct me if I'm wrong, but I think the summer heating assistance only came around after COVID. Is that correct?
It's been a possibility, but we don't always have the funding.
Right.
And so during COVID we did have, and so Since that time, we've been able to operate a spring-summer cooling program. But you are correct. Most recently, it's been because of the funding associated with COVID.
Okay.
All right. So the income eligibility is set at 150% FPL. So you can see one household with one member's 1823. Truly is for the low income. Next slide, please. So we'll talk about the benefits. We've talked a little bit about that already. Of course, payment assistance, utility bill assistance is the major one. And we offer a subsidy component and then a crisis component. And then emergency assistance, that could be the crisis component mentioned there, or that could be emergency assistance through community action if somebody is really in crisis and they need maybe temporary heating unit of some kind, or even blankets, I think, could come into play there, that kind of thing. And then, of course, weatherization activities to increase energy efficiency of the family's home. Next slide, please. So the subsidy component assists with their monthly heating cost. And as I said a while ago, the benefits are structured based on the poverty level and then the fuel type. And so it's adjusted there, estimated on that amount, cost of those different fuel types. Generally, the fall subsidy runs early November through mid-December. However, community action does does operate, I think, what they call early enrollment in October, starting in October, for elderly individuals and individuals with disabilities. And then, of course, appointments are available for those who are working and need to work around that work schedule. So the crisis component is especially for those households who are out of fuel or almost out of fuel, really in crisis, and that's primarily in the wintertime when it's a life-threatening situation to experience a heating crisis. And that usually runs early January, usually the first week of January will be that start date through March 31st. And then those benefits for crisis are limited to the amount needed to relieve that crisis. So that'll depend on fuel type. And then for metered fuel, it's a maximum of $400 for gas or electric. So cooling, we talked about cooling. Certainly, it's only when we have funding available do we operate a cooling program, used exactly as we said to offset cooling costs. And again, those are subsidy. That's a subsidy type benefit, so it's structured on poverty level and fuel cost. And this year we operated the spring cooling subsidy April through May of this year. So here are some numbers for the state fiscal year, and sometimes it gets a little confusing. The plan and the funding run on FFY, federal fiscal year. Our contract with Community Action on the state fiscal year. So these are numbers for the state fiscal year. So 46,000, just under 47,000 households received assistance in the cooling subsidy program. That was for an average benefit of $142.92, and that was a total of $6.7 million. And then just over, 104,639 households received assistance in the heating crisis. So that would have been January through March of this year. Average household benefit, $244.44, and $25.5 million was spent in crisis. And then 71,494 households received heating subsidy, and that was an average benefit of $136.12 and $9.7 million in total benefits spent. So, as I said, we transfer, I think it's 15% of the total yearly grant to Kentucky Housing to offer, they actually combine it with their Department of Energy funding to operate the weatherization program here in Kentucky. And that program helps fund home repairs related to energy efficiency and different interventions of that type to increase the efficiency of that home and safety overall. And that serves low-income households 200% FPL or below. Next slide, please. So the priorities or weatherization is prioritized based on households that contain elderly or disabled or children, and then children at risk of removal due to substandard conditions of the home, and then high energy burden households where the energy costs exceed 15% or more of the household's income. So I think I covered this. It includes activities to increase the energy efficiency of the home and reduce heating costs. Examples: installing insulation, sealing air infiltration, and then heating system and water heater repair. Also focused on improving the health and safety of the dwelling and heating systems. So things like testing for gas leaks, carbon monoxide, other health and safety issues, checking appliances for safety, installing fire and carbon monoxide detectors, energy education, that's a big one. And then here's some numbers. 165 homes were weatherized between last July and December, with an average benefit of $7,985. And that, as I said, uses a combination of LIHEAP and DOE funding. And so now I'm going to hand it off to my partner here from Community Action Kentucky.
Yes, we work very closely with the cabinet in administering the Low-Income Home Energy Assistance Program. Is one program that we operate, but we also operate several other programs with the cabinet as well. There are 23 community action agencies across the state of Kentucky that cover all 120 counties, and we have a physical office presence in all 120 of those counties. And again, they are funded through the Community Services Block Grant, which again is operated through the cabinet to where we have the infrastructure to where we can operate several other programs, not only low-income programs, but we also operate a lot of other programs that are designed for the general public. We always like to say if you've seen one community action agency, you've seen one community action agency because they're all different. They have some core programs like LIHEAP that we operate, that every agency operates, but then we have a lot of other unique programs like transportation, domestic violence programs, shelters, you name it. We literally serve from birth through early Head Start all the way through senior citizens programs. We have, again, outreach offices in all 120 counties. We employ continuous quality improvement processes. We have a LIHEAP change committee that every year reviews the program, works with the cabinet to see what issues or challenges we have so that we can make those changes and make the program even better from year to year. We have manual updates based upon technical assistance and monitoring trends for every year. There is a full program manual that's available for the program. We do data collection and analysis through a centralized computer intake program and provide training and technical assistance to the Community Action Network on a regular basis. We go out to the agencies to provide that training and technical assistance, and then we also have an annual conference to where we have topics specifically around energy and LIHEAP and all the other programs that we operate throughout Community Action.
All right, thank you all very much. Any questions?
Any members have questions? Representative Johnson.
Thank you, Mr. Chairman. Just real quick, in the local county offices you have, how do people find you? Is there a coordination with local government, or what is it? What's the process?
every community action agency has a tripartite board of directors, which in most counties, the chief elected official, which is typically the county judge executive, sits on all of the community action agencies boards. We do lots of media and outreach. I know back in home in Hazard, where I was from, we had WYMT that we always did local interviews with that was really good about getting the word out. Every agency has a Facebook page, and in today's world, that's where people receive a lot of information is on Facebook. So we try to use every avenue that we can to get the word out, and not only that we're accepting applications, but exactly what people need to bring in to apply so they don't have to make numerous trips to the office.
Thank you. Thank you, Mr. Chairman.
Representative White?
Yeah, thank you, Mr. Chairman. Mr. Trapp, I see that your enrollment on the for cooling cost is April through May. What would happen if somebody in the midsummer, July or August, happened to get in a situation where they needed assistance but they didn't know it by May? Is
So we offer the very good question. I'm glad you asked that. We offer the spring program to assist with that exact thing for those folks who maybe don't experience it until the end of the winter. Some of those metered fuel folks who get that big bill at the end of the winter. So that's why we offer that spring. And then we have started, because we have the funding available, let's be clear on that, a cooling program the middle of July, actually yesterday, I believe, through it'll run through mid-September for those folks who experience that cooling, that utility assistance issue, as you say, a little bit later in the summer. So we hope to be able to continue to do that. We certainly want to operate that and have operated that when we've had the funding available.
well, thank you, sir.
Thank you.
Okay, then that's one of the limits of the program is that, once the funding is no longer, then the program ends for that particular year. So, members, if you look in your packet, you will see a LIHEAP block grant application, and it has some proposed findings of fact. And so what I would need is a motion to adopt the finding of fact. We have a motion.
I make a motion.
Second. All those in favor signify by saying aye.
Aye.
All, any opposed, like sign. Okay, the motion does carry, and so I think then now the cabinet will actually make the formal application. And so this really, we've done what we have to do as the legislature to conclude our, I guess, our.
Yes, thank you all very much.
Okay, thank you very much.
Thank you very much.
One of the things that we're going to talk about today is, as part of the process of the committee is to study issues that are going to affect us next year or, even now. And so we're going to have a discussion of the U.S. EPA rule on greenhouse gas standards for fossil fueled fired power plants. And one of the things that, we know that the Biden administration has proposed new rules, and these new rules will increase utility cost, and that's going to affect every Kentuckian. And it's our responsibility as the representatives of the citizens is to let people know that what is coming and what the results of these. Now, these are still in a stage where there's comment periods and that sort of thing, and so I guess they're not finalized yet. It's very possible that the election this November could change what happens, but at any rate, if we continue on the current path, then there's no question that next year we could see large rate increases that could affect not only the affordability but the reliability of our electric system to our customers. And so what we're going to do now is have an explanation of the rule, and we're always glad to have Tony Hatton, the Commissioner of the Department for Environmental Protection, and who's always up on these issues. And Tony, we welcome you and appreciate you kind of give us some insight on what you're expecting these rules to be. Thank you.
Let me hit that button.
Great.
I'll remember it one of
It's
these
better.
days.
Much better.
Yes, so Chairman Gooch, Co-Chairman Smith, and members of the committee, I appreciate the opportunity to be here today to give you just sort of an overview. And I might need a little help getting this slideshow started. I apologize. Thank you.
And we do have a copy of your presentation in the members' packets as well.
Well, I always endeavor to never read a PowerPoint to anybody, so I don't intend to do that today either. But we'll just sort of look at it from the. And so what I sort of want to talk with you all about, because of the request, is sort of a treetop view of the greenhouse gas rulemaking that EPA promulgated, and may be in the final stage by now. It may be a final rule by now. We can certainly check on that. But they published it back May 9th of this year. Sort of the department's role in issues related to this type of federal rulemaking is within the department. We have the Division for Air Quality. Division for Air Quality's primary role is to implement federal Clean Air Act rules and also to implement any state-specific rules that may exist. And we're going to find out today. I'm going to indicate to you later today that there are some state-specific rules also that speak to the implementation of the greenhouse gas rule, or perhaps are contrary to what the greenhouse gas rule currently says. And so we're primarily a technical agency. We are also responsible for completing state plans, state implementation plans, anytime a rulemaking comes down related to air quality. We are an authorized state to implement. So just from a high level, if you all have a copy of this, do I necessarily need to forward it? Or I can?
We have a copy.
Okay. So just, like I said, from the treetop view, just an overview of what that final rule does and its purpose, which is ultimately to reduce carbon dioxide emissions from fossil fueled power plants. A discussion of the impact that the rule will have on current and future electric generation in Kentucky. And I can speak to that intuitively, although I assume, Chairman Gooch, you're going to have some people here today that can speak to it more directly than I can. But, you know, intuition, no value judgment, but intuition says that there will be impacts, potential impacts to current and future electric generation. And then a question about the state plan. The federal rule requires the state to prepare and submit to EPA by May 9th of 2026 a state plan to implement this greenhouse gas rule as it's currently drafted. So just real high level, I guess, in summary, the rule repeals the Affordable Clean Energy Act, which has been stayed for a significant period of time. And the Affordable Clean Energy Act was primarily geared towards utilities undertaking efficiencies at their plant within their fence line to reduce their carbon dioxide emissions. And as I understand, many of those efficiencies have taken place. This greenhouse gas rule, for lack of a better way to put it, it has new requirements that would befall an electric generating unit that may be things beyond their direct control and certainly outside their own fence line, efficiencies that they themselves may not be able to obtain or implement on their own. So it sort of widens out, I guess maybe one way to put it, the number of stakeholders that would need to be involved in order to be in compliance with the greenhouse gas rule. I think two things. It requires new source performance standards for generating units that are going to undergo a large modification that might be either new or reconstructed. And secondly, regarding existing generating units, it has new emission guidelines or emission standards that are established in the rules. We'll get to those here in just a second, what those are. There's a couple of tables here, and they're real general, but they give you an idea of what the rule's looking at accomplishing. On that first table, on the left you have unit types, which is really listed there based on the expectation for the period of time that unit is intended to continue operation. So for long-term units that are slated to retire sometime after 2040, the best system of emission reductions, that's at BSER, would require by January of 2032 that there would be 90% capture of carbon, and it would be sequestered. And EPA estimates that would result in an 88%.
I'm sorry. Can you give us that date again?
It's January 1 of 2032 that for long-term units, the best system of emissions reductions will require 90% capture of carbon dioxide, which EPA suggests would lead to an 88% reduction in CO2 emissions. For intermediate units that are looking at retiring January of 2039, the second part of the standard, you have that first one, which is carbon sequestration. The second one would be co-firing with other sources of energy. As you can see there on the table, those units would be required to co-fire with natural gas at a 40% rate, which EPA suggests would result in a 16% reduction in CO2 emission rate. And you have short-term units retire prior to 2032. Those would permanently cease operations as of January 1 of 2032. The next table on the unit type has more to do with the amount of time that it operates to provide the energy that's needed. So we're looking at base load, we're looking at intermediate load, and low load. So the best system of emissions reductions for a base load unit, that's a unit that operates consistently to provide base load electricity to meet the needs of residents, industry, and all the needs that there are. That carbon sequestration requirement of 90% capture is there. That resulted in an emission standard that you can see there between, and I don't need to read those out, those are the emission standards of carbon dioxide per megawatt hour. And the compliance date is January 1 of 2032. We continue to look, but as I understand it right now, regarding new and reconstructed fossil fuel-fired combustion turbine units, which is this subject of this table, that intermediate load and low loads currently have no compliance date. That could be for a lot of reasons, and they may be in there, but I haven't been able to ferret them out. Some of the other more qualified experts than me may be able to enlighten us on that. The Cabinet, through our Division of Air Quality, submitted comments to EPA on August 8, 2023, and to some degree they were adverse comments, and I'll explain the reasons why. Primarily having to do with implementability. So carbon capture sequestration, we believe, and we commented, is not appropriate as a best system of emission reduction. And the reason why is I couldn't even begin to fathom, I don't have the information or knowledge to even begin to understand what a cost might be. I can intuitively say it costs a lot, but I'm looking at it from an implementability standpoint. That seems like a long time, but that's a few short years away. And some of the things that we thought is it's an assumption in the rule that you're actually going to be able to obtain that kind of capacity by 2032, and I simply don't believe it's feasible for the following reasons. In order to sequester carbon, you've got to have subsurface pore space that has a sufficient capacity to receive that carbon dioxide and then sequester it. So you have to have pretty specific geologic conditions, which is something I do know a little bit about, whereby when you can inject the carbon into the pore space, it's going to stay there. I mean, in some places now people use carbon dioxide injection for secondary enhancement, for oil well recovery, those types of things. But in this particular application, you're going to have to find sufficient pore space where the material can be sequestered for a significant period of time. A second, and I think really difficult challenge, is going to be securing access to that pore space. As far as I know, there's not a large chunk of property sitting somewhere that's been specifically set aside for carbon sequestration. You're going to encounter issues where you got private landowners. In some states, you may have issues where you have surface right owners, mineral right owners. That can become extremely complicated. That's all there is to it. And the geology's got to be such that that capacity will contain the carbon. I've mentioned geologic constraints there. I've already talked about those a little bit. Another one is transportation challenges, is being able to get the carbon dioxide from the point at which it's generated to where the sequestration is. Something else that should be considered, and this may have a little bit to do with reliability or a sufficient amount of energy to meet the needs. Carbon sequestration at a unit will also require a significant amount of that energy generated at that unit to be used just to sequester the carbon. I've heard numbers like 30%. It's commonly referred to as a parasitic load. So those are challenges that carbon sequestration legitimately proposes. Now, this second bullet here, this bottom was only 2 bullets, so the last bullet, I can't say with any assurance that I fully understand what would happen, and maybe others can explain it, if carbon sequestration is not available when these deadlines meet. Does that mean we're in a situation where that unit has to discontinue operation, where that unit has to operate in noncompliance, or where that unit can continue to operate under the emergency provisions that are in the greenhouse gas rule? Not to mention there are also FERC requirements that might seem to be a little bit on a collision course there, but I don't fully understand all of that, but that seems to be the potential outcomes. The original rule also mentioned hydrogen as a coal-firing energy source, and that's a comment that the cabinet also made for the same reason, not a value judgment, but is it an assumption that's actually obtainable and implementable? And we just based on what we know, feeling pretty confident that low greenhouse gas hydrogen to the volumes that would need to be available is not going to be feasible within that time frame. EPA eventually removed that requirement from the final rule. Fuel switching and beyond the fence line. And so beyond the fence line is the point to be made about how this is a reversal of the previous Affordable Clean Energy Act. This rule places requirements beyond the fence line that the cabinet has no control over in its operation of its state air permitting program, such as the carbon sequestration, the generation of low greenhouse gas. But in a state plan, we'll have to have provisions in order for us to have a state plan that would meet the requirements of the greenhouse gas rule, or of this particular rule. It's difficult, if not impossible, for the agency to do that when there are additional stakeholders and additional infrastructure needed here that we have absolutely no control over. In one of our comments, we did say back to EPA that this proposal seems to conflict with the Supreme Court ruling in West Virginia versus EPA, which held that Congress never granted EPA the authority to require generation shifting under the Clean Air Act. But yet, that is one thing clearly that the rule does. And another comment that, and I think we provided a copy of our comments to each of the committee members for your reading enjoyment if you'd like to, or for your education. The proposed rule establishes carbon sequestration and hydrogen co-firing as a BSER, and neither one of those have been adequately demonstrated. And I'm not speaking just from a cost perspective, but from an actual obtainable implementation perspective. This one is important to everybody. I think it's important to everybody, no matter where you fall on these issues from a philosophical standpoint, but grid reliability is something we all want to have and maintain. And, you know, recently, about a month or so ago, maybe a little more than a month or so ago, there were a host of federal rulemakings that came down, many of which were related to this particular industry and a couple to others, and that impact the power sector, like the ELG there. I realize that's an acronym. That's the Effluent Limitation Guideline. Here's where you see a situation of where electric generating units have made, in some cases, significant capital improvements to treat their water before they discharge it, water that particularly comes in contact with coal ash or flue gas desulfurization. They have invested some, I know for sure, invested significant amounts of dollars into treating that water prior to discharging it, which is a good thing. Under the new LG rule, they're not allowed to discharge any water that comes in contact with these materials, irrespective of whether or not they've treated it or not. So I'm not real sure that any cost-benefit analysis that's been done might fully respect the true cost of efforts that have been undertaken which are no longer going to be allowable. You take that along with the coal combustion residual rule, which I'm very familiar with, the mercury air toxics, PM 2.5, the good neighbor rule, regional haze, and several other rulemakings. And what you sort of end up with here is there's a host of rulemakings that might, in and of themselves, have a cost-benefit analysis. But on the whole, maybe those cost-benefit analysis don't reflect the true cost of the activity, of the action, and don't seem to address them collectively, because collectively we're beginning to look at a significant amount of cost, which, as you mentioned, Chairman Gooch, gets passed along to the ratepayers. We did say that due to the potential for ongoing grid reliability issues, we did agree with the emergency provisions of the proposed rule that says, you know, if you have to have energy, just go ahead and generate it. That last bullet, the rule potentially forces state permitting authorities like us to choose between meeting requirements of the Clean Air Act and a permit, or providing electricity as required by the Federal Energy Regulatory Commission. That may be what it comes down to, and that puts a permitting agency in a tight spot, and we'll finish up with that conversation here on the next slide. It puts us in a really tight spot, because we have a responsibility to make sure that we are properly permitting these types of facilities, but at the same time, we endeavor for our permits to be protective, but still allow for a sufficient amount of energy to be produced to meet the needs of the Commonwealth, whether it's residential, industrial, economic development opportunities, all of which are important to across the board. So this last slide is really summarized, but it appears as though, maybe that's not putting it strongly enough, it does appear that the provisions of the greenhouse gas rule as it's currently drafted do conflict with state law. In Chapter 224, which is the controlling statutes for our agency, particularly in .20 and in subsections 142 through about 146 or so, it specifically states in there, and I've just listed a few examples, that the Division for Air Quality cannot submit to EPA, shall not submit to EPA a state plan, and we're speaking here of coal units right now. We cannot submit a state plan that prohibits switching from coal to other fuels, that prohibits coal-firing fuels with coal, and prohibits limiting the utilization of an EGU while reducing carbon dioxide emissions. So that's clear in our state law, which conflicts with federal rules. If you look at that statute, you went on down to 143, it also has some of the same provisions regarding natural gas facilities. 144 and 145 direct the department that, if necessary, it can look at proposing less stringent standards, that it can take a higher amount of accountability about what the exact costs are and compliance schedules. Because in a state plan, it's not just going to be a broad plan. We'll need to have a specific plan for every one of these units. We'll have to do a survey, talk to them, which we do, and tailor a state plan that specifically takes into account what's going on in each unit. So, long story short, even though it's a couple of years out, as we sit here today, we have conflicting requirements in the greenhouse gas rule and what a state rule also requires us to do. I think it's a little early yet. I think a lot of things can happen. It takes a while to put together a state plan. It's not something you do over the course of a week. So you don't have a whole lot of time to see how things unfold, but I think right now, a lot of things can happen in the next couple of years. Who knows what will happen? So this is a decision that we're going to have to look at in the not too distant future about how we move forward, because we have, at least as it sits here now, two controlling rules that conflict with one another. So Chairman Gooch, that's the breadth and depth of my presentation. I'd be glad to try to answer any questions that I can.
Thank you, Commissioner Haddon. And I do believe that your comments pretty much listed all of the things that I've had that are certainly issues with the new rule, and there's no question that you listed, I think, pretty much all of them, and I appreciate the work that you did on that.
Yeah.
We do have a question. I think Representative Blanton may have a question.
Thank you, Mr. Chairman, and thank you, Commissioner. I'm up here
Yes, sir.
behind the post. Just real quickly, going back to page 4 to the slides there on the long-term units, intermediate term, short-term. Do you have a breakdown of how many of each one of those facilities we have in Kentucky?
I do, but I don't have it with me, but I will get it to you.
Okay.
So I think you're probably looking, I think there are 11 or 12 somewhere in that area that might be base load units. Or you may have at a facility, you may have one unit that's base and one that's intermediate and one that's low. You might have across the board at a particular unit, but I can get that information to you.
Okay.
But I think to some degree, this is going to affect each and every significant fossil fuel fired electric generation unit in the state.
Yeah. So we're essentially because of these regulations that they're pushing down, we're going to end up losing some plants or some partial plants, and we're going to increase rates for our customers across the Commonwealth and weaken our power grid is what I'm hearing from all this if this all comes into play. Thank you, Mr. Chairman.
Representative White.
Thank you, Mr. Chairman. I have a question that is looking in the future, Mr. Hatton. Is there a possibility the change of administration on the federal level would ease some of these restrictions on the EPA regulations, or is this set in concrete?
Well, I appreciate the question. I can't answer that because I don't know. I'm simply responsible for looking at this from an implementation standpoint. Certainly there is lots of conversation about differences of opinion on these types of issues, but I can't answer that. Yeah. It would just be a surmise, and I'm not in the business of surmising.
So, but the state has to state has to abide by the federal guidelines on this, I guess.
The state is a clean air, so the federal rule is the Clean Air Act, and the state of Kentucky is authorized to implement the Clean Air Act. So when this rule comes out, we have to submit a plan to EPA saying how we are going to implement this federal rule. That's why we have to give them a state plan. Mm-hmm. As I mentioned earlier, we have state-specific laws here in Chapter 224 that directly conflict with what the new federal rule would require us to put in our state plan. So it's really, there's no clear path forward because they are so contradictory to one another. Okay. And I can't speak for utilities, but other than to say that it puts everybody in a little bit of an uncertain pickle as to how you move forward.
Okay. Thank you, sir.
Mm-hmm.
Well, I mean, I think one of the things that we have to point out is that the Clean Air Act in 1990 was actually written and specifically designed to work on pollution and pollutants like carbon and those types of, not carbon, but sulfur dioxide, nitrous oxide, soot, particulate matter, all those things. Never mentioned carbon because it wasn't classified at that time as a pollutant. And it was just through the Supreme Court's, I guess, endangerment finding that allowed EPA to go back and pretty much rewrite the congressional law and regulate it as a health endangerment to human health. And we've had some Supreme Court rulings that I'm hopeful now with the Exxon rule that actually says that the agency can't do that. And so but at some point we have those two things don't really mesh, and I don't know. We don't know yet whether it might be that there'll be another Supreme Court ruling when you have, or which one of those laws comes. Can you allow Congress to regulate carbon and mention a bill that never was intended to address carbon as a pollutant? And that's kind of what the Exxon rule, I think, tries to avoid. So we still have a lot of unanswered questions. And but the problem that we have is that what they are with the new rule, the things they're talking about, 90% sequestration of carbon dioxide is probably not even possible. Certainly not feasible. It's not it's not something that can be done as far as cost is concerned. And so there's still a lot of unanswered questions out there. We have to certainly look at our ability to maintain reliability and affordability. And the problem is that generally, you'll have every administration will have maybe one rule that we look at that's really going to have an impact, and so it's going to raise rates, it's going to do whatever. But with this administration, we probably have a dozen of those rules. And when you look at the MATS rule and the good neighbor rule and all the other types of things, the smog and all of those combined, and as you mentioned, you can't capture the carbon if you don't have any place to put it. And these power plants aren't sitting on top caverns where you can just put it in the ground. You can in some places they actually use the carbon dioxide in enhanced oil recovery, and that works pretty good. But there's not enough situations where we can use all the carbons, or even beverage industry or whatever. So we have we have to make sure that that the proposals that are being presented are doable. And I think that's the problem that I have, is that I don't see them actually being doable at this point.
And Chairman Gooch, if I might, I think I might have an answer to Representative Blanton's
Okay, go
question.
ahead.
So it appears that only 2 units in Kentucky have committed to retire prior to 2032, and those have been through approval, and that there are 26 units impacted otherwise across the state.
Let me ask you a question. Of those 2 that have been, my understanding is that the rule would actually allow them to run 100% wide open at this point.
It
Is
would.
Yeah, they can.
It
So
would.
I think that the utilities ought to be doing that. Is that these plants that are going to close anyway, let's use them and utilize them all. And I guess they probably are, as far as the extent to that they're able to be cost effective.
Right.
But,
And meet the demand.
yeah. And so anyway, Senator Smith, I think, has a comment or question.
Yeah, I have a comment and a question. During the Obama administration, we saw a lot of this overreach was affecting Texas, and Texas litigated. They began to fight back. Their AG's office, supported by their Senate and their General Assembly, really pushed back hard and were able to delay enough to get reprieve and keep moving. And they, one time, I think their GDP was probably the greatest in the country during this time. So they were able to resist and fight back in court. Do you know if our administration is going to give you all the authority to put the legal team into place to push back against the EPA and honor the fact that as we joined the union, Kentucky held out special rights, saying that if the federal government got off the reservation, if you will, we choose not to go that way if it's in a direct conflict with what the interest in the Commonwealth of Kentucky. So for all of us who have to go home and tell the people we represent, is the administration going to fight the EPA? Is this something that we are going to have to approach the AG and have the AG do it?
Well, I believe, and I know there may be some testimony on this today, there's been, I think, 24 state attorney generals that have filed appeals against the greenhouse gas rule. We filed adverse comments, and it's not uncommon for us to coordinate with the Attorney General's office on some of these federal rulemakings. There have been times when our Division for Air Quality Directors provided affidavits and such as that. So we talk back and forth, and so that's what we have said here. We have listed adverse comments, the biggest one being as this rule conflicts with state law, and that's the big one in our statutes.
Well, thank you. And certainly to follow up on Senator Smith's comments is that we are glad that the Attorney General is actually involved in many of those lawsuits, and we're going to have testimony today from their office. But it certainly would be good for the Governor of the Commonwealth to weigh in on a matter that's this critical to the state. So
I do believe he has weighed in.
Okay,
He
thank you.
has, yes.
We appreciate your testimony today.
Absolutely.
Next, we're going to have the discussion of that legal challenge to the rule. And first, I think we have Allison Wood, who with McGuire Woods. Okay. Welcome. Please introduce yourself for the record, and the floor is yours.
Thank you, Chairman Gooch. I'm going to try to figure out how to get my slide up.
If not, we'll have a
See if it just comes
staff
up
person
next.
help you with that.
It does not. Oh, there it is. There you go. Thank you. Sorry about that. I'm Allison Wood. I'm a partner with McGuire Woods, and in a moment, I'll give you some of my qualifications in case anyone here is wondering, why should we listen to, what you have to say. I did want to just very briefly begin by following up on Commissioner Hatton to let you all know that this is in fact a final rule. It is being litigated vigorously by not just states, but also many industry parties. And I'm going to talk a bit about that litigation, as is Mr. Maddox. There are 27 states that are challenging the final greenhouse gas rule, including the Commonwealth of Kentucky. And there are 22 states that are defending it, siding with EPA. And if you do quick math there, you can see that's 49 states, meaning almost every single state in the nation is on one side or the other. In case you're wondering who the lone holdout is, it's the state of Nevada. So today, like I said, I was going to tell you a little bit about myself, and then I'm going to give you a little bit of background on how EPA has tried to regulate greenhouse gases from power plants before. The thing you need to know is this is its third attempt. The first two have been struck down. And then I'm going to talk to you a little bit about, the legal issues with this greenhouse gas rule. All right, so, who am I, and, why should you listen to me? I was part of the team that challenged EPA's first rule under this Clean Air Act provision, the Clean Power Plan. I represented the electric generation industry in that case, and we obtained a stay of that rule from the U.S. Supreme Court, so it never went into effect. I also represented a trade association that has coal and electric generation interests in litigation over the second rule, which was called the Affordable Clean Energy Rule, ACE rule. That is the case that ends up going up to the Supreme Court, the West Virginia versus EPA case that is now, that struck down the approach used in the Clean Power Plan, said that EPA had been too narrow, possibly under the ACE rule, and has now led to the third rule. In this third rule, I represent before the DC Circuit some investor-owned electric generators and a public power trade association that are part of an ad hoc group called the Electric Generators for Sensible Transition that are challenging the rule in the DC Circuit. That ad hoc coalition includes from Kentucky, AEP, Duke Energy, Kentucky Power Company, Kentucky Utilities Company, and LG&E. I want to express that, to the extent I'm talking about facts are facts, but if I give you an opinion on something, that opinion belongs to me. I don't want it to be attributed to my client. People might agree with me, but they may not. And I also was part of the team that I have clients. We recently got a stay from the U.S. Supreme Court of the Good Neighbor Plan. This is a nationwide stay. You all here in the Commonwealth of Kentucky were lucky because your AG went right away, challenged the disapproval of your state plan, and so you had gotten a stay earlier, but there were many states, 11 states, that were not so lucky. But at the end of June, we got from the Supreme Court a stay that is now nationwide. I have testified before Congress on these rules before, twice before the House and once before the Senate. So I want to give you just the quick background, and it is a little bit like a ping pong game that's been going on for a long time. So we started with the Clean Power Plan under President Obama, And that put in place two different types of rules for power plants. One's for new, and then one's for existing, coal and gas. That was challenged, held in abeyance, and I was one of the people who argued it before the DC Circuit, but the decision never came out. It was argued in September of 2016. The election happened. President Trump was elected. And then what happened was when he came into office, the case was put in abeyance, and then it went away once a new rule came out replacing the Clean Power Plan. That was the ACE rule. And then we almost had a repeat where environmental groups and some other states challenged that as not going far enough. And, it was all briefed. It was argued in the DC Circuit in October of 2020. We had an election, went to President Biden, and everyone thought, oh, we're going to have the same thing happen again, where we won't get a decision. But we did get a decision from the DC Circuit on January 19, which, if you're thinking about what's the date of the inauguration, was the day before. And so clearly the court also realized that that might happen again. That then went up to the Supreme Court. And what the DC Circuit had said was that the ACE rule didn't go far enough. So it goes up, and this then becomes the case West Virginia versus EPA. And in this case, in a 6-3 decision, the Supreme Court says that EPA, it looks at the Clean Power Plan as part of looking at this because it repealed the ACE rule repealed the Clean Power Plan. And they uphold that because what they say is that in the Clean Power Plan, the Obama rule, that EPA had gone too far and had exceeded the authority given to it by Congress under the Clean Air Act. It also gave rise, this case, to something that is called the Major Questions Doctrine. So what the Major Questions Doctrine is and where it comes out of this case is it talks about the fact that there are extraordinary cases where courts really need to examine, does the agency, and this can be any federal agency, not just EPA, did Congress actually intend to give this authority to the agency? And the types of extraordinary cases are ones where, they're suddenly an agency's doing something that's not normally in its lane. They're suddenly finding some big authority that they've never claimed before. Things that are very economically and politically significant. And there, what the Supreme Court said is, when we see this, we have to hesitate and really look, did Congress actually mean to allow the agency to do that? And with regard to the Clean Power Plan, the answer was no. And in looking at that, what they basically said was that in the Clean Power Plan, EPA was dictating what the optimal mix of energy sources should be in the United States. And they were prioritizing in this order. First, wind and solar, followed by natural gas, and followed last by coal. And the court said EPA doesn't have the authority to do that. They said, particularly in this provision that they were relying on, that the Supreme Court called a previously little used backwater. And they said that they noted that Congress had consistently rejected proposals to create this type of a program. I have in bold at the top the fact that the Supreme Court said that all previous 111D rules had been based on things that you could do at the source itself, technology measures. I'm bolding that because that is now on this new rule what EPA is saying that it is doing. That is what they're hanging their hat on. So let's talk about that new rule. Okay, you'll see here I have a wolf in sheep's clothing because that is what this new rule is. So in the Clean Power Plan under President Obama, EPA is really, really open about what it's doing. that generation shifting is what it's called. You know, we're going to do wind and solar, then we'll do gas, which gas generation emits about half the greenhouse gases that coal does. We're only going to do coal last. Supreme Court says you can't do that. You have to do this technology-based best systems of emission reduction. So that is what EPA has done, and that's what it says it's doing, but it is the exact same wolf dressed in the sheep's clothing, because at the end of the day, the things that EPA has chosen, the technologies that it has put in place in this rule, they're either not available yet, not adequately demonstrated is the language of the Clean Air Act, or they can't be achievable. And what it's going to lead to is two things. First, coal plants in this country, the bulk of them will retire by 2032. If you're a coal plant that's lucky enough to have a supply of natural gas, you might be able to put that off until 2039. But that's as long as you're going to be able to go. And then any new gas generation that you build is going to have to be severely curtailed under these rules. So that it's leading to the same result. This is the statute. I'm not going to read it to you, but the things you need to know is that a standard of performance is supposed to be based on a best system of emission reduction. That's the BSER that the commissioner was talking about. And that BSER needs to be based on technology that is adequately demonstrated, achievable, and is cost effective. And then there are two different types of provisions we're talking about here. The first are under 111B as in boy, and those apply to new sources. And so here, what I'm going to talk about are the standards for new gas plants. And then under 111D, as in dog, are the guidelines that apply to existing coal plants. And for the second set, that program is supposed to actually run through the states. So EPA sets guidelines, and then the states do plans, and those are due by May of 2026. And then that's when that regulation starts. But for these new sources, that regulation is in effect right now. In fact, it applies to any new gas plant that's being constructed anytime after May 23rd, 2023. Okay, so let's talk about the new, and then the next slide, we're going to talk about existing coal. So for new natural gas combustion turbines, and again, this now applies. This is in effect right now. A source can choose what it wants to do here, okay? So, the owners of a plant can say, okay, I can be low load, which means you almost never use it at all. I could be intermediate load, which means I use it a little bit more, up to 40% of its capacity factor, or I can be base load. The low load and the intermediate load have standards that can actually be met. So that's not the problem. The problem is the base load. So basically, if you want to build a new gas plant and you want to operate it at more than 40% of what it's actually capable of doing, right now you need to meet a performance standard of 800 to 900 pounds of CO2 per megawatt hour is the standard, and that depends whether you're on the 8 or the 900, depends on the base load rating for the plant. But here's the problem. Beginning on January 1, 2032, you suddenly have to meet a 100 pound per megawatt hour standard that is not achievable by any plant. That is based on doing the carbon capture and storage and having to be able to do that. And you have to be able to do that by January 1, 2032. So what this rule is doing in essence is it's going to force the closure of the existing coal. I'm going to talk about that on the next slide. And then when the power companies try to build new gas to replace it, those new gas plants can't operate more than 40% of what they're actually able to do. So if you think about this from like a car perspective, it's like if Chairman Gooch, you need to drive 25,000 miles a year for your job and your personal use of your car, and suddenly someone told you, well, you can't drive any vehicle more than 10,000 miles a year. And so you're sitting there with your car and you can't drive it more than 10,000 miles a year under this law, but you still need to be able to do your job and, support your family. You need to be able to drive 25,000. So what are you going to do? You're going to end up with 3 cars in your garage so that you can still, do what you need to do. That's what this rule is doing with gas. For existing coal, again, this will be part of the state plans that each state has to do, and the owners of the existing coal plants need to decide, are they going to be a unit that retires, a unit that's a medium-term unit, or a long-term unit. So you think, well, they have a choice, but actually at the end of the day, no, they don't really have a choice. Because the things that they have to do for the medium or the long term are not achievable. And that then means that you're going to have to then commit to retire by January 1, 2032. And that commitment has to be part of your state plan that is due in less than 2 years. So if you agree to permanently retire by January 1, 2032, you're exempt. And I guess for the 2 plants that we just talked about that have already committed to do that, they'll be okay. But I scribbled down the number that the commissioner said somewhere on here, and I'm not seeing it. But 26 units impacted. So for the other 26, they have to decide, okay, I either have to close down by January 1, 2032, regardless of whether the plant has more useful life in it, or I could deem myself a medium-term unit, which basically means you're going to have to co-fire 40% natural gas in the unit to meet the limit that EPA has put in place. And you have to do that by January 1, 2030. So if you're lucky and you actually have gas coming to the plant in enough quantity that you can do that, that might be a possibility, and that'll buy you another 7 years to January 1, 2039. But the fact of the matter is, most plants don't have that type of gas supply, and they won't be able to get it by January 1, 2030. So they'll end up having to retire as well. Plus, one of the things the commissioner was talking about here is, at least in the Commonwealth of Kentucky, you're not allowed to co-fire that gas. That was what he was talking about. And then if you want to try to operate after January 1, 2039, you have to meet that. You have to be capturing 90% of your CO2. That's based on the carbon capture and storage. And so that's what the rule does.
I have a couple of questions. If
Sure.
we can do that now.
And then we'll go to the legal issues.
Okay. Senator Smith first.
Yeah, I just want to make a comment. You were using the analogy of having the one car, et cetera, but I was with the Clean Air Task Force in China before the Olympics, and so the government there decided they were going to obviously get some more of the what they call blue sky days. They were going to clean it up to where you could actually see the sky, and so they did exactly this. And you may know this, they limited this, but when I was there with the task force, every single industry we went to couldn't wait to get past the preliminaries and the introductions so they could show us their new generators that they had purchased in America. And so they would use their quota from the government, and then as soon as they reached their 10,000 megawatts or whatever they had, they would fire up these generators, which was cause pollution at a different level than I think China had ever dreamed would happen. So we watched it fail tremendously there. So it's just shocking to look at this unfold again and put something so silly out for the American public so we can do something China did 10 years ago. But
It's interesting that you raised the generator issue, because one of the things I'm going to talk about, one of the legal issues is that this threatens grid reliability. And I was thinking a lot about this during the LIHEAP presentation that preceded the discussion of this rule. And one of the things that's going to happen is the grid is going to become unreliable and power will go on and off. Everyone in this room, I would hazard a guess, what we'll do is exactly what you said, Senator. We're going to put a generator on our house because we're fortunate enough to be able to do that. And it'll flip on when the power goes out. But I was thinking about those low-income people who can't buy a generator and whose bills are going to go up by a large amount from trying to comply with this rule. All the replacement generation that's going to need to be constructed, that's going to pass down to the consumer. And one of the things that was said during that LIHEAP presentation was that 15%, anyone whose electric bills or their gas bills were 15% of their income, that they were prioritized under the LIHEAP program. And what ran through my mind when he said that was that number of who's 15% of their income for their electric bills, that number's going to go up. It's going to be a lot more people.
Representative Dotson?
Thank you, Chairman. You made a comment prior that really stirred a question in me concerning when the EPA initially came out and set the rule that the base load had to be wind, solar, natural gas, then coal. And then the Supreme Court made the ruling saying that you can't go this route without technology. My concern is, and I just want to know for my own self and for the committee's benefit, when the EPA has to provide that technology-driven data, is that within EPA, or is there a third party is there technology even available to be able to quantify those numbers?
Well, in the rulemaking, EPA provides data that they say supports this. And one of the things when I get to the legal issues is I'll show some of the data. The record for EPA saying this can be done is frankly very thin. Mm-hmm. And that's one of the legal issues with the rule. But they have to have already presented it. And they say, it can be done.
So is there a third party involved?
No. I mean, they rely on reports and, scientific reports and things like that. What they're really looking at is evidence of, has this been done before? So, for example, with regard to existing coal plants, they look at basically two plants. One is a plant called the Boundary Dam plant. It's up in Saskatchewan, Canada. It is maybe around 150 megawatts, which is not very big. And they said that provided evidence that, because that plant does have carbon capture and storage, they said it provided evidence that you can capture at the 90% rate that they're requiring. One of the things to know, though, is the owners of that plant sent an email during the comment period to EPA and said they were correcting EPA and said the plant could not do that. It might have done it 1 or 2 days, but it could not do it consistently. And they were very unequivocal in that. The second plant that they cite for the 90% carbon capture and storage is a plant called Petronova in Texas. And that plant, the CO2 is used for enhanced oil recovery. So they take the CO2 that they separate and then they use it for oil exploration. That plant has suffered with first of all, it has not met the 90% level. Secondly, it has suffered from not being economical. So the plant was shut down. It was opened in 2016, shut down in May of 2020, and it only just restarted in September of last year. So there's your two examples that they cite. It's like I said, the record is thin.
my concern is just a follow-up comment, is that the EPA has been so politically weaponized against coal that, to have unbiased data, driven data with, with outside source, I just didn't know if that was what the Supreme Court was looking for in that ruling.
That isn't really what the Supreme Court was saying. What the Supreme Court was saying in West Virginia was Congress has to very clearly have given EPA this authority, and Congress has not given EPA the authority to generation shift. You can't just nakedly say, all right, to address climate change, we're going to have wind and solar dispatch first, followed by gas, followed by coal. You can't. EPA can't require that. But instead, what they've done now, by putting in place these, relying on things that are not adequately demonstrated, that are not achievable, they've put the electric generators in this country in a position where their choice is to retire the plant or break the law. They can't break the law. So the plants are going to be retired.
Thank you.
All right, legal issues. And we've touched on a lot of them, so I'll try to be quick. The first is the fact that, CCS is not adequately demonstrated. To be adequately demonstrated technology under the Clean Air Act, the technology needs to be dependable, effective, cost-effective, and it has to be based on some actual operating experience. You cannot, under this provision of the Clean Air Act, there are others where this is okay, but it's not okay under this provision. You can't justify the rule by saying we're trying to stimulate the development of the technology. That's not allowed here. It has to already be developed. We talked about Boundary Dam and Petronova just now and what those problems were. For the gas plants, there is not a full-scale gas plant anywhere operating CCS. And in support, in response to Representative Dotson's question about the record, what EPA cites is a plant that is no longer operational, that was in Bellingham, Massachusetts, that captured only a tiny 40 megawatt slipstream. And then a plant called Mongstad, which is in Norway or Sweden, I can't remember which, I'm sorry, that is only a 12 megawatt facility, so teeny, teeny, tiny. And that's at a CCS testing center. So the fact that it's a testing center tells you that it's not adequately demonstrated. And then under the Clean Air Act, not only does the technology need to be adequately demonstrated, it needs to be proven to be achievable. In other words, you can meet these rates that you're being required to do. And there is zero evidence in the record that shows that these emission limits can be met consistently 24/7 by the plants. There's some citations in the record to vendor statements, where a vendor tells you it can do it. But the case law from the DC Circuit is clear that those cannot stand on their own. They have to be backed by some actual real-world evidence. And the bottom line is, and the commissioner touched on this, the infrastructure that we would need to be able to do CCS, even if it were adequately demonstrated, even if we knew we could do it, it does not exist right now. There are not CO2 pipelines. They would need to be constructed. There are not the Class 6 wells that would need to be permitted, and that's the geology of where you would put the CO2 down. Those things don't exist. And one of the things EPA keeps pointing to is that the Inflation Reduction Act, which has provisions in it for CCS, tax credits that go to you for doing it, that makes the rule cost effective. But the fact of the matter is, the fact that Congress is giving incentives to stimulate the development of CCS actually underscores that it's not developed technology. Otherwise, they wouldn't need to give incentives to do it. And the second thing that EPA says is they say that CCS actually results in a negative cost to the electric generators, that in other words, you'll get so much tax credit, you'll make money from doing this. I have to tell you, as a lawyer who's represented electric generators for over 20 years, if they thought that they were going to make money from doing this, they'd be fighting each other to the door to try to get those credits. And they're not. They're not, because they know this technology doesn't work. And they know they can't hit that timetable. And you only get the tax credit, not for trying, you get the tax credit for succeeding. You have to meet certain, levels of capture. And what if you don't? So that piece of it doesn't work either. And then in terms of this co-firing of natural gas at a coal plant, the thing that would buy you the additional 7 years, that's a big legal issue, because EPA has never had authority to force someone to change their fuel type. And this is just, again, that generation shifting that the Supreme Court said no. Also, the co-firing fails because it's not achievable. Achievability under the Clean Air Act requires that everyone be able to do it. It's like the floor that every unit in the nation can meet. But I already explained, by far the vast majority of coal plants don't have access to natural gas. Only about a third do. And of that third that do, only 4% of the third get enough natural gas coming to them that they could actually generate electricity with it. So what most of those 1/3 of the plants use the gas for is they use it during startup, or they use it to hold the boiler in warm standby. There's not enough coming to generate electricity. So that, another legal issue. Then finally, it violates the major questions doctrine, violates what the Supreme Court said in West Virginia versus EPA. And basically, it goes back to the wolf in sheep's clothing. This is the Clean Power Plan dressed up differently. And what EPA cannot do directly, it cannot do indirectly either. And at the end of the day, this rule ends you in the exact same place the Clean Power Plan did. Coal is retired, gas is restricted, and wind and solar and other renewables are preferred. The other thing that might be of importance to you, and I'm sure it's, and I don't want to go into it too much in case Mr. Maddox wants to, but the rule interferes with the rights of states. So we talked about the fact that for these existing plants, you have 2 years to put in place your state plan for how you want to do it. And the Clean Air Act says that states have the right in setting those standards to take into account remaining useful life and other factors when those standards are set. But EPA in this rule basically puts in place presumptive standards for you and says that those are virtual requirements, and that a state could deviate from that if they want to make it more stringent. But what if you need to make it less? And then, they're saying, well, you might be able to make it less, or you might be able to have a different methodology if there's going to be like anticipated changes in how the plant operates. Under the Clean Air Act, EPA is allowed to express a preferred approach. That's fine, but it cannot make it so that the state has to take that. And so that is another legal issue as to whether the state's rights are being curtailed here. And this is my last slide. There's a whole host of other issues. I went into more detail on what I consider to be the big ones, and you can look at these later. The thing to know, and I'm going to tee up Mr. Maddox for you, is that there are stay motions that have been filed with the D.C. Circuit to try to stay this rule. We are awaiting at any moment a ruling from the D.C. Circuit on that. And in support of that stay motion were several declarations from Kentucky utilities explaining how bad this would be for those companies and for Kentucky citizens. And so he will talk a little bit about that.
Okay, thank you very much. I think it's been very informative, and most of us already knew, but it's great to have someone that understands the issues being able to come in and explain to us why. You know, it's not enough just to say that something won't work, but you know, having the data and someone with expertise to tell us why it won't work does give us much help, and we appreciate your presentation.
Thank you.
Thank you very much. Next, we're going to have a discussion on the legal challenges from the Attorney General's office. Vic Maddox, ask you to come forward, and we've got about 20 minutes to, hopefully you can get your presentation done in that time.
Certainly, Mr. Chairman, and thank you. I'm Victor Maddox. I'm counsel for special litigation in the Office of Attorney General Russell Coleman, and I appreciate the opportunity to talk to you today about the legal challenge to the rule that Ms. Wood has explained very capably. She's correct that we are part of a coalition of 26 attorney generals who have filed a petition to challenge the rule in the D.C. Court of Appeals, which is where we are required by the Clean Air Act to bring such a challenge. We filed our final brief in the stay motion. I think it was a month ago today. And as you heard, we are awaiting a decision by the D.C. Circuit on that stay. You know, without a stay, the rule is currently in effect. I believe it went into effect July 8th. And so there are, you know, aspects of it that are requiring the utilities in Kentucky to take action even now. I think the rule explicitly says that they expect utilities to begin work toward compliance if they are intending to implement carbon capture and sequestration immediately, or by June of 2024, which is, you know, last month. And as Ms. Wood said, you know, this rule effectively seeks to shut down coal-fired electricity generation, severely limit natural gas electricity generation, and compel a shift to so-called renewables. And I want to just, I don't like to read a lot, but I want to read you the first paragraph of our final brief in the D.C. Circuit, which this is in reply to the EPA's brief trying to explain why none of the legal problems you just heard about are true. The EPA believes that they are not requiring generation shifting. The last slide pointed out that in the West Virginia case, that rule actually required a reduction from 38% to 27% coal-fired generation. The EPA's position in this case is they're not requiring any such reduction by any stated percentage. They're simply saying if you want to go forward with coal-fired generation after 2032, then you have to capture your carbon. And the EPA's position is that sure, there will be less coal-fired generation in the decade of the 30s, but that won't be because of their rule. That will be just because electric utilities are making their own decisions. And you know, effectively, they're doing exactly what Ms. Wood said. They are doing indirectly what they were told just 2 years ago they can't do directly. So we said in our final brief, the EPA tries to make itself largely unaccountable to anyone. It believes that uttering the words technology-based standards or best system of emission reductions overcomes the charges that it's repeating the errors from the last go-round. It thinks the court, the D.C. Circuit, must defer to its judgments about real-world practicalities, so much so that the court can't scrutinize the EPA's hope that coal plants will hit the hurried and unreasonable targets. And it supposes that it can pair state discretion, the authority that you all as a body and this General Assembly has, in a cooperative federalism framework can pare that to the bone. And of course, we believe all that's wrong. The rule sets undemonstrated, unachievable standards that states can mitigate in the rarest, except in the rarest of EPA-controlled circumstances, such as the test that Ms. Wood told you about in Norway. It remakes the power sector by compelling otherwise avoidable retirements when electricity grids are already struggling. And these unlawful efforts saddle the petitioners, in this case the states, Kentucky and all the others, with immediate and irrecoverable costs. Now, I wanted to try to make concrete what has been somewhat abstract already. What are those irrecoverable costs? And in the materials that I believe you have in your packet, there are the affidavits or the declarations put into the DC case, both by John Crockett, who is the president of LG&E KU, and Jerry Purvis, who is the vice president of EK, Eastern Kentucky Power Cooperative. And these are the declarations that demonstrate the harms to the state of Kentucky, to all of your constituents, and to the industry in general. And in addition to those declarations, because they total about 75 pages, I've given you a short summary of some of the key paragraphs in those declarations. For instance, in John Crockett's declaration, he said that the rule will result in the following impacts: premature and accelerated retirement of 4,750 megawatts of nameplate capacity, nearly 55% of its generating fleet, with a current net book value of $5.2 billion. He said that it would result in the accelerated construction of replacement generation, which, given current supply chain constraints, cannot be met. He said in his declaration that LG&E has never tried to build more than one unit at a time. This rule will require it to build 7 or 8 simultaneously. He said in paragraph 3 that this would all cost at least $7 billion for replacement generation alone. And that doesn't even consider the costs of gas transmission infrastructure, which doesn't exist, the upgrades, the certain cost escalation impacts due to the compressed compliance schedule, and other costs, such as design, acquisition, legal challenges, the inevitable delays caused by the NEPA challenges that will come. And I think LG&E has been trying for the last 10 years to build a 12-mile gas pipeline in Nelson County. And this carbon capture sequestration would require LG&E and EK, Eastern Kentucky Power, to build pipelines 300 miles to Illinois because, as you all know, Kentucky has karst topography and it's just not suitable for storing carbon dioxide. He said that, under the rule, LG&E is essentially prohibited from operating its coal-fired generation beyond year-end 2031. And then in the last paragraph that I've highlighted for you, paragraph 24, he said, multiple choke points in this complex and lengthy compliance implementation chain pose serious risks to grid reliability, especially in the decade of the 2030s. That's 5 or 6 years from now, if the existing generation must retire according to the rule. And he said that this poses a serious risk of blackouts, brownouts, curtailment of interruptible customers, and by that I believe he means they'll just be turning off power to customers who aren't essential, and other service interruptions that will harm the safety, welfare, and prosperity of Kentucky residents. That's what LG&E says this rule will do. Now, what about East Kentucky Power? Mr. Purvis, who's the Vice President for Environment, says that the final rule has the effect of frustrating East Kentucky's ability to provide reliable and affordable power. He says that in paragraph 66 of his declaration, reliability consequences are at stake prior to the resolution of this litigation, which could take years, because due to the increased demand for power in Kentucky and the premature retirements and limitations that the rule imposes. I think one of the things John Crockett also said in his declaration is that the rule requires the compliance efforts to begin immediately. And so without a stay, this rule is in effect. All of these costs are going to begin immediately. And I believe Commissioner Haddon said that, Kentucky has to put its air quality plan, its state implementation plan into effect in 2026. LG&E has got to make commitments, binding commitments about what plan it's going to retire, almost immediately before that plan can be created and submitted in a timely fashion. The Purvis Declaration talks about two key power plants that Eastern Kentucky has, the Cooper Station and the Perlock Station. Both of those have remaining lives extending past 2045, but they're going to have to be shut down by 2032 if they can't commit to doing this unachievable, unworkable, and unbelievably expensive carbon capture system. He says that this system, CCS, by 2032 is impossible at Spurlock and Cooper. He says the CCS capital project on its own would cost $6.2 billion for all 4 Spurlock units. He says Eastern Kentucky must shoulder, and this is in paragraph 38 of his declaration, Eastern Kentucky Power must shoulder $10.7 billion in costs during project developments and in the early years of CCS operation. So that number far exceeds the cooperative's entire balance sheet and its ability to support this financing activity. And get this, after investing billions of dollars for CCS, Eastern Kentucky Power would produce fewer megawatts of electrical generation than it produces now due to parasitic load. Finally, he says this is going to have a staggering rate increase for all of your constituents, at least those in the Eastern Kentucky footprint. 67 to 96% increase to residential bills, solely based on adding CCS to Spurlock. He says an increase of this size is staggering and not possible. And finally, he says the price tag is unquestionably excessive, and CCS as a compliance strategy is unsustainable and dangerously naive. So that's what we're trying to stop with our stay motion in the D.C. Circuit. It's anybody's guess what the D.C. Circuit Court of Appeals will do. In the previous go-rounds, that court, which is a majority of judges appointed, I believe, by Presidents Obama and Biden, has not been receptive to the challenges brought by the states and by the power companies. It remains to be seen what they'll do in this case. Of course, we are prepared to go to the United States Supreme Court immediately if the stay is denied. One of the things that's ironic about all this is, and I believe that this has been said in public elsewhere, but the truth is that if this rule goes into effect, it will result in more carbon dioxide emissions. In part, that's because, for instance, LG&E's most efficient new gas plant, its Mill Creek 5 plant, which could run at 90%, is going to have to run at 40%. And so LG&E is going to have to run its coal-fired plants as long as they can, as much as they can, to provide the generation that it would have gotten from a much cleaner gas-fired plant. And on a global scale, what this rule will do is force electricity generation out of the United States to China and to Indonesia and to other Asian countries that are much dirtier, so that the worldwide emissions will go up as well. One of the things I put into your materials for your consideration is some science material, and I did this for the reason that, the EPA did its endangerment finding in 2009, and that was following the Supreme Court's decision in 2007, and that endangerment finding was really based on science that had started in the early 90s and was, still developing even in the early 2000s. One of the things that you'll see in there is a paper by Professor Lindzen and Happer. Professor Lindzen is a professor of Earth, atmospheric, and planetary Sciences at the MIT, Massachusetts Institute of Technology. Professor Happer is a professor of physics emeritus at Princeton. And they've put a paper in that's been published in the Cornell University papers. I believe I gave that into your materials as well, that says that as we sit here today, carbon dioxide has become a weak greenhouse gas. And that's because of something that they believe physics demonstrates called the saturation effect. The more carbon dioxide you put into the atmosphere, the less of a warming effect it has. And this curve is asymptotic. And so it becomes almost a flat curve. And what they say is that you could double the amount of carbon dioxide from today. That would take about a century at current levels. But the amount of additional warming that it caused would be trivial. And I believe they said it would be on the order of 0.17 degrees centigrade. So that is, a process that I don't believe the EPA has considered. We think the EPA should consider it, and we think that as these cases go forward, there may be an opportunity to present this sort of material to the court for consideration. One of the ways a rule can be demonstrated to be arbitrary and capricious is if the agency, here the EPA, overlooked or ignored an important aspect of the problem. And the question here is carbon dioxide really an important greenhouse gas at this point? Is it causing the problem that the EPA wants to solve? And will its elimination or reduction actually result in the result that it seeks? So I throw all that out there for you, for your consideration. And finally, just one last thing. John Horn is here. He heads up our Office of Rate Intervention, where the Attorney General's office, basically intervenes in PSC cases to make sure that the interests of ratepayers are represented. And it points out, this is a report by the International Energy Forum, May of 2024, copper mining and vehicle electrification. The whole purpose of this EPA rule is to eliminate fossil fuels and to require everything to be electrified. Cars, electricity generation, your home, every appliance, you name it. What this report demonstrates is that we don't have enough copper to possibly satisfy the demand that these rules, if they were ever implemented, would require. It says copper availability and demand determine the rate of electrification, which is the foundation of current climate policy. Many studies have raised the concerns that copper supply cannot meet the copper demands of both the green energy transition and equitable global development. But the seemingly universal presumption persists that the copper needed for the green transition will be somehow available. It says this need not be the case, and then it says, just to meet business as usual trends, 115% more copper must be mined in the next 30 years than has been mined in the history of humankind. So that's just remarkable. That would be, in essence, we would need 905 million tons of copper in the next 30 years. In all of human history, we've mined 757 million tons. So there's a lot of scientific questions. There's obviously questions about, whether this rule makes any sense whatsoever. We believe that we can demonstrate to the court that the EPA does not have the statutory authority to do this rule, which is always the first question in an administrative procedure challenge. We also believe we can demonstrate that it is arbitrary and capricious. Happy to answer any questions.
Thank you. Very good presentation. I think one of the things that we're seeing is that the leaders in this country are really trying to force us to fuel switch, which would decrease the amount of coal, and we've already greatly decreased the amount of coal that's been used for generation in this country. I think I just saw though that last year I think there was 8.5 billion metric tons of coal. I think it was the first time ever, it's the largest amount ever that's been used worldwide. So, I think the real question that many of us have is that, you know, this is happening worldwide where they're actually increasing the coal, but yet we are willing to subject our citizens to 67 to 90% rate increases in this country for because of the so-called existential threat of climate change, and I mean, it's mind-boggling to me, and I don't.
Mr. Chairman,
Yes.
I think you're exactly right, and I was looking for some material that I have from the Statistical Review of World Energy, and it demonstrates that since 2000 to 2022, you know, CO2 emissions in China, India, in particular, have increased dramatically, and in fact, in the 6 largest economies in those 22 years ending 2022, the United States reduced its carbon emissions by just about 900 million tons per year. India increased its carbon emissions in that same period by 1.5 billion tons per year. And China increased its carbon emissions in those 22 years by over 7 billion tons per year. So we are shifting electricity generation, carbon emissions, and the like from this country and Western, you know, economies to China, which is reaping the benefits of, you know, basically a wide open energy policy, and we can see the consequences in all manner of ways.
Yeah, it just makes us, we can't compete when we're allowing them to use the fuel that we are rejecting in this country, and it's a real problem. Thank you for not only your presentation today, but certainly give our regards to the Attorney General, and thank you for what you're doing there to help protect the citizens of Kentucky from well, I'm not going to say.
I'll certainly do that, Mr. Chairman,
Okay.
and appreciate the opportunity again. Thank
All right,
you.
Thank you. And I appreciate the members staying this long. It's been a long committee meeting. If you notice, there are some administrative regulations. There are no actions that's required this time, but certainly if anyone has any questions, does any member have any questions about any of the regulations? Okay. If not, I think I have a motion. I need a motion to adjourn.